All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
All right. Is the state ready? Okay. Is the defendant ready? If you will call the case, please.
Case number SC 2024-0771, ex parte, State of Alabama. Arguing for the petitioner, the Honorable Dylan Malden. And arguing for the respondent, the Honorable Zach Alsobrook.
Thank you. May it please the court, Dylan Malden for the state of Alabama. First-degree voyeurism, taking pictures or videos of the intimate areas of another person without their consent and for the purpose of sexual gratification, is a sex offense. And because sex offenses are not subject to Section 1518H's 3-year limitation, probation, Cofer's original probationary term was lawful. In this case, no one, not any court and not even Cofer, has disputed that first-degree voyeurism is, in fact, a sex offense. And that is unsurprising. Section 1528.5 lists 41 different ways that a crime can constitute a sex offense. That includes 32 specific crimes and 9 separate catch-all provisions. It states that crimes just like voyeurism, classified as sex offenses, like indecent exposure and peeping. And it even makes explicit that video voyeurism is covered. In this case, first-degree voyeurism fits neatly within 3 different definitions of a sex offense. It falls within paragraph 39 twice over. First, because it is a crime that is in any way known or characterized as video voyeurism, and also because first-degree voyeurism requires a finding of sexual motivation. It also fits within paragraph 33 because voyeurism is a sex offense that is the equivalent to listed offenses. Rather than dispute the obvious that first-degree voyeurism is a sex offense at least 3 times over, Cofer contends that he may not be subject to his original and lawful sentence because of the ex post facto and double jeopardy clauses. But applying Section 1528.5's plain text as it existed when Cofer committed voyeurism, and thus reinstating his original sentence, is not a retroactive punishment, and it doesn't put him twice in jeopardy for the same offense. And as mentioned, first-degree voyeurism falls within 3 different definitions of a sex offense. And paragraph 39, as I mentioned, it covers any crime committed in any jurisdiction, irrespective of the specific description or elements, which is any way characterized or known as video voyeurism. And first-degree voyeurism is taking pictures or videos of the intimate areas of another person. And that is video voyeurism. And if you look at the video voyeurism statutes in Arkansas and Louisiana, which we cite in our brief, they're almost identical. The Arkansas video voyeurism statute, it bars videoing a person who has a reasonable expectation of privacy without their consent. And the Louisiana video voyeurism statute covers videoing another person who has a reasonable expectation of privacy. Or video.
Let me ask you this question. The statute's changed now, correct?
Yes.
Today, there would be no doubt, there would be no legal question at all that this was within this, that this was going to be subject to unlimited probation, right?
Yes.
Okay. So, is this a decision that's only about this one person?
So I think it has a broader effect because it depends on how you interpret the statute that defines sex offenses. So if you construe it narrowly and say that a specific crime has to be listed, or else it violates ex post facto clause or double jeopardy, which is what Cofer is arguing, then yes, absolutely it would, because every time there's a new sex offense, the legislature would have to go back and add that specific crime, and also more broadly, this.
Well, I mean, I'm kind of convinced by your video voyeurism argument. I mean, that's specifically listed in the statute, even though that's not the name of the crime here. And that seems like a pretty specific description. So assuming we were to agree with you that that's video voyeurism, it's not necessary anymore, though, because the statute includes this enumerated crime now, right?
Well, perhaps, but again, this statute, it comes at multiple different angles to make sure that any possible sex offense is covered. And in this case, the statute was on the books for a while under the sex offense definition as existed. And in this case, and it's just as necessary that those offenders are, for one, subject to a SORCNA. If video voyeurism does not fit the definition as it previously existed, they're not sex offenders in Alabama. So that definitely does matter. It also matters to the length of probation here, because we had a judge who heard.
I'm not following you. I understand why it would matter to this person. I mean, I get that. I'm trying to understand why if we write an opinion, why it would have any effect on anybody else, except for the more general idea that things ought to be listed or not. And how is our opinion going to have any impact except for this one person?
Well, so again, as you mentioned, it certainly has an impact here. It could have an impact on anyone else who committed this crime in between the amendment of the statute, and just how this statute is interpreted more broadly going further. But I mean, this is a sentence that was lawful when it was imposed, that the CCA erroneously vacated on its own sua sponte. No one raised it. No one has defended it even. And, the states
But if
just
it's illegal, it's jurisdictional, so they can do it sua sponte.
Yes, I agree. If it were illegal, there's some precedent supporting that it could, but this sentence was not illegal. And I think it just kind of goes to show the harm of when courts sua sponte, get it, sentencing issues.
Mr. Malden.
Briefing.
It's Mr. Malden, correct?
Yes, Your Honor.
Right. Thank you. And there's a reason I'm asking this. Did you handle the case in front of the Court of Criminal Appeals?
No, Your Honor.
Okay. Well, maybe you can still comment on it. It picks up on just what Justice Wise was mentioning and a little bit of what Justice Cook said. But the Court of Criminal Appeals did this sua sponte on its own. The state nor the defense was able to respond or argue it to the Court of Criminal Appeals. And in light of the overall procedural posture, do you think that the state in this instance should have filed an application for rehearing before the case went back down to Lee County?
So under Ex parte Harris, because the CCA ordered a return to remand, the decision wasn't final, so we couldn't seek rehearing or we couldn't seek certiorari from this court. We had to wait for it to go back down.
I understand. But the defense did not file an application for rehearing, correct?
No, they did not.
Just the state did.
Yes.
Okay.
And getting into the ex post facto arguments, the ex post facto clause, it prevents states from retroactively increasing punishment. And when Cofer committed the offense, as I discussed, voyeurism was a crime. The statute that defines sex offenses covered voyeurism. And it makes no difference that the statute was not listed at the time. For that statute makes clear that a crime not be specifically cited, the statute that criminalizes the conduct to be covered.
Mr. Walden, can I ask you a question? When the trial court imposed the original 8-year probation sentence, did he have the defendant sign a SORNA violation at that point?
So in the, I believe it's page 104 of the record, there is like a sentencing order and additional notes. He instructed the defendant to follow SORCNA. And there have been multiple orders like that, or SORNA, I apologize, the federal sex offender statute. And there's never been any dispute whatsoever that the defendant was required to register as a sex offender. Now, if voyeurism wasn't a sex offense, then he shouldn't have had to register.
Right, but if the trial judge had that 8-year probation and indicated on the record that he's to follow the rules of SORNA and go to probation office and sign up and do all of that stuff, wouldn't that have given the defendant notice that the trial judge at least thought this was a sex crime?
Oh, absolutely. And the defendant did have notice. So at sentencing, originally the trial judge thought that the probationary term was limited to 3 years under 1518(8)(b). But the state raised the point, no, like because this is a sex offense, that does not apply. And the judge went back and forth, had to pull up the statutes and look. And Cofer never once said, no, this isn't a sex offense. I'm not subject to that. And so he had a chance then. He could have argued, no, this isn't a sex offense.
Then I had one other question for you. So the criminals send this back to the trial judge. There is a new sentence, and there is no dispute that the new sentence that was imposed is a valid sentence, right?
No.
There is a dispute?
Sorry.
It's probably by poorly phrased question.
Yes, it is lawful, but I mean, the order that directed the court to impose that was erroneous.
Right. And this defendant has served almost all of that second lawful sentencing order, right?
He has served a good deal of it. I believe he has roughly a year left, but Cofer's counsel correct me if I'm wrong. But again, there's 5 more years that the trial judge thought that he should serve, and this is the trial judge who heard all the facts, heard testimony from the victim, from Cofer, and heard about how Cofer, he started out just taking videos from his own room, but then he ended up taking 21 over a period of a couple weeks, and he became so obsessed that he got to the point to where he crept right outside the victim's window and was recording through like a crack in the blinds, essentially. And he decided, no, 8 years is the probationary term that's necessary in this case, given the extraordinary high recidivism rates that appear in sex offenders. And that is presumably the reason the legislature decided that sex offenders should not be subject to the 3-year limitation on probation, and it's why we have SORNA and SORCNA and all these regulations on sex offenders. And I'm picking back up with ex post facto clause, as we've just discussing, Cofer always had notice that the state thought this was a sex offense, that the trial court thought it was a sex offense, and the statute defining sex offenses, it didn't change. We're asking for the statute's plain terms to be applied as they existed when he committed the offense. But if this court making it explicit that video voyeurism was a sex offense amounted to some ex post facto violation, you would think there would at least be a colorable argument on the other side for why voyeurism is not covered by, for instance, the statute's specification that video voyeurism is covered, or that crimes involving sexual motivation, that would cover a crime where an element is the purpose of committing it with sexual gratification. But there's been no argument whatsoever that voyeurism is not a sex offense. So it can't be that this court just making that clear would amount to an ex post facto violation. And it doesn't violate double jeopardy either. The Constitution, of course, prevents the state from trying a defendant multiple times. Cofer doesn't really have any argument for why double jeopardy is violated here. He just has vague reference to the double jeopardy clause. But in no way does the double jeopardy clause prevent a state from appealing an erroneous intermediate appellate court decision. And it doesn't even bar the states from appealing an erroneous trial court sentencing decision. And here, we're not even asking for resentencing, which would be much closer to the double jeopardy clause area. All we're asking for is that this court reverse the CCA and reinstate the original sentence. And I'm sorry. If there are no further questions, I'll reserve the balance of my time for rebuttal. Thank you.
May it please the court, Zach Alsterbrook for the defendant. I have been the defendant's attorney from the beginning of this case all the way through, and I'll be honest, standing before you in this particular instance, in which I didn't actually raise the issue that as to why we're here, makes it somewhat awkward because I guess it was the court that ultimately determined this, as was stated earlier, as was their right when it comes to sentencing. The issue in this, and it's hard for me to make, as was stated earlier, a colorable argument because there are such terms in the statute, such as video voyeurism, and I believe a statute under 33 regarding a male person peeping into a room, which would then include those within the statute. However, none of those are specific to this charge. I guess my argument that I would make on behalf of the Court of Criminal Appeals is only that there was 41 various descriptions and statutes, very specific, in which code sections were set out, and this particular statute was not. And perhaps that's why it went through, or why the Court of Criminal Appeals made that decision. Just on its face, the legislature had not placed it there. And of course, the legislature being the one that creates the law at that point in time, the Court of Criminal Appeals found that this was not, and it did not apply, and that 1518.8 did apply. The issue that I was brought up, and really the main reason that I entered in an appeal, as was the statement stated earlier, whether it's ex post facto, the argument is simply that the code section by our legislature had not specifically stated that. It was sent back, and most importantly, a lawful order was entered. Now, I'll be at the argument that it was, I don't want to say coerced, but it was an argument, it was an order that was sent back on remand that was entered in. No one's arguing that order is not legal and lawful. Mr. Cofer has completed. He entered his 1-year sentence in October of 2020. I'm sorry, excuse me, October 21st of 2022. Got out shortly before that, so he's not. If I apologize. He will be concluded with his probation under Judge Tickle's the trial court's newest sentence, October of this year. He has moved forward in his life, has made a drastic change in his life, and to then turn back around and pull it back. The argument would be that that's the exact reason why there is a prohibition against ex post facto. And the application here, by bringing it back on this one instance, would be, well, the argument is unconstitutional. I do believe, and I want to clear a few things up, I think there was a statement that notice was argued before the first sentence regarding this probationary term. If it was with a different defense counsel. That was news. Now, there was argument at the re-sentence as to why it should not be with the new trial judge, but originally when it was entered in, there was no such original argument. And when it came through, the argument that went there and it brought back, of course, all the appeals applicable things that I argue were, of course, denied, but the court returned this back upon it then coming, Mr. Cofer coming to court and getting a new sentence, with it being legal and lawful, the new sentence, even with an application of this. My argument is that it does not apply. I will not stand before you and make a argument that the statute that is set before you, that we're talking about today, especially in sections 33, 39, and I believe 41, probably do apply to voyeurism. I'm not certain why legislature in September of the year when all this actually occurred did not bring that into it, as it was also modified, I believe, the same time that this statute was created. That would be voyeurism, but it did not. So without that being there, I would argue that to now turn around and create new legislative law, if that's what we're now arguing or saying that, I would say would be ex post facto. Now, we'll at this time withdraw I know that was a very awkward statement. Thank you for your patience in terms of how I'm trying to argue this. It, again, wasn't my holding or finding. It was the Court of Criminal Appeals, and I'll argue only before you today that if the court were to agree with the state, it should not apply to Trevor Cofer. He has more than met his sentence. He has done everything that's been asked of him. Everything's been paid forward and then turned back around and bring him back into the probationary circle when he's now married and moved off and things like that would be unfair to him. So I would add, and in my argument, would be unconstitutional.
So just to clarify, how long did he serve in jail?
He served 1 year in jail.
Was it the local jail or did he go to prison?
He stayed in Lee County. Yes, sir.
Okay, so, and now he's had almost 3 years of probation?
It'll be 3 in October of this year. Yes, Your Honor.
So I don't understand, just honestly, your ex post facto argument. We're construing the act, the statute that was in effect at the time he was convicted and at the time he committed this crime. So how is that ex post facto?
Well, I think the argument would be that the new order that resentenced him from the trial court in Lee County would be a new order and it's legal and lawful. Now, to say that the Court of Criminal Appeals was wrong in their order would be an acceptable use of that, but then to overturn an order that was entered in by the trial judge and add back what was originally entered by the prior trial judge, I would argue would be ex post facto because it's essentially bringing back an order and overturning a legal and lawful order, which is now standing there. And clearly, the statute, even if it's a matter, and there's
So you're saying the state can't appeal now. It should have appealed earlier?
Yeah, there was no appeal made immediately upon the Court of Criminal Appeals entering that in there. There was no.
Could the state have appealed at that point?
I think they could have asked for a rehearing at that point, and I believe that wasn't done until after the order. I may be wrong on my dates in that regard, but once a new order entered in is kind of the point I'm saying, that at that point there was now an order, and that's when the state began filing in additional pleadings after the fact. So I would argue that at that point in time we have a new legal and lawful order, and there's really no grounds to say it's illegal if the court follows me.
So if we were to agree with the state, your position would be as long as we make this prospective and not retroactive, and so it wouldn't affect your client. That's a position I think you may have argued in your brief or something.
That is a much clearer way of saying everything I just said. Yes, I'm not standing here taking a position basically as to that because I can't disagree with that statement. Obviously, from my client's standpoint, it would behoove me to concur with the Court of Criminal Appeals, but I agree with the argument that was made earlier. I mean, under the color of law and as it's laid out, I don't make that argument, but I would argue it should be proactive going forward, not retroactive to my client.
Thank you.
Sir. I reserve my time unless there's any other questions. Thank you.
Thank you. I just have a few really quick points. First, for the discussion between the trial court and the state about whether Cofer was subject to the 3-year limitation on the probationary period. That's at record page 587. And it goes for about 10 pages. It's a pretty lengthy discussion. And then additionally on ex post facto clause, the only ex post facto clause argument I'm hearing is that you can't go back and undo a sentence that's already been imposed. But the ex post facto clause, that's about retroactively increasing punishments in the sense that a punishment was not available when the crime was committed or that certain conduct was not criminal when it was committed. But it's well established that states can appeal sentences in general.
I agree with you. But what about the point about whether you could have sought rehearing at the time the Court of Criminal Appeals said that this was subject to a 3-year limitation?
So we could have sought rehearing in the Court of Criminal Appeals. So it's our understanding that was not available. It wouldn't have been a final decision.
I'm sorry, you think you could or could not have sought?
Could not have.
You could not have.
That's correct. So really our only opportunity was to allow for the remand back to the trial court and then appeal to this court. It doesn't make it an ex post facto violation, a double jeopardy clause violation. If this trial court made the same error in the first instance, it still wouldn't violate ex post facto clause. And if there are no further questions.
Go ahead.
Now, so does the fact that he substantially served his sentence Does that have any bearing with your argument, number one? And then this thing that I ask your opposing counsel is, if we were to do what you're asking us to do and made this simply prospective and not retroactive, is that acceptable to you all?
No, I don't think it is. And so mainly going to the point, like, does it matter these almost finished with this sentence? So I apologize, this case is not cited in our brief, but there's a double jeopardy clause case called United States v. DeFrancesco. And what that case holds is that in double jeopardy for sentences, there's not a legitimate interest in the finality of a sentence while the appeals are ongoing, essentially. That the state is, if by statute is allowed to appeal and challenge the sentence, there's no interest in repose, basically, once the sentence is ongoing. And here, that's all we've done. We've taken the ordinary appellate process to challenge this erroneous ruling. So it doesn't make a difference that he's not completed his sentence in this case.
I'm assuming I probably should have asked the defendant's attorney this, but I've been out of the criminal courts for 8+ years now, but at least it used to could be you could get an appeal bond for a 1-year sentence in the county jail. I assume the defendant did not. I mean, as far as this whole ex post facto argument, he could still be out on appeal bond, I assume, couldn't he?
So I'm not aware, but of course he's just been on probation the entire time.
Oh, he said he served a year in the.
Oh yes, but yes, that is correct. But for the duration of our appeal, I believe it's been probation the entire time.
Sure.
Yes.
But yeah, if he'd been out on appeal bond, though, he wouldn't be serving any of that until the appeal was final.
So I have no reason to disagree with any of that.
So we granted cert to rule to answers and briefs in this case, and under Rule 39 of the appellate rules. And it says, if you got an issue of first impression, and that's what you claim is the issue of first impression, right?
Yes.
If there is a material question of first impression. So tell me why this is a material question of first impression if it just applies to Mr. Cofer since the law has changed.
Well, so again, I'm not sure it would just apply to Mr. Cofer. It would apply to anyone in between the changes in the law. Anyone who had committed voyeurism. It could also apply to someone who had committed a sex offense in another state if this court is going to decide that it takes a very literal and narrow interpretation of the sex offender statute. Kind of broad implications going forward across a whole manner of assortment cases. Thank you.
We stand adjourned. Thank you all very much for your time.
All rise. Court is adjourned.